The primary reasons that we hear new workers leave, the first is that the administrative duties that are required as part of this job take them away from working with children and families. They go into this work really having a passion for working with kids and working with families, and they don't realize there's that administrative component. There's prep work for court, there's reviewing paperwork with your supervisor, there's immense documentation.
That's probably the biggest challenge initially when you first come into this position, I found, is being able to prioritize what do I need to do and when do I need to do it throughout the day. So it takes a minute to get your footing and realize what you need to do first to get it all done, and accept that it will never all be done. You document everything. It's the foundation of building that case, regardless of the direction that case is going to go ultimately. Everything you're doing and documenting along the way is going to support that end decision for what's best for those children and that family. You document all your contact with parents, emails, phone conversations, even communication at court. You'll document on your end, and with service providers and child advocates. All the communication you have supports the work you're doing.
We are going to Marion County Juvenile Court, to the Annex building, and the hearing is actually it's a disposition. So I had to prepare a predispositional report, which we call PDR, and essentially the parents will be ordered to engage in services. They'll formally be ordered to engage in services, and in this case, they've already begun engaging in services, kind of to get a head start on things, and really both parents want their child back in the home with them, which is a good thing. That's not always the case, and so that's wonderful.
One of the things that's so important, anytime anyone is in court, by and large, there are some exceptions I'm sure, it's kind of a nerve-wracking thing because there's someone who's going to make big decisions about little people who are in their lives. And going into that and thinking, do I have the right evidence? Am I going to say the right things? What if I forget something? What if I freeze up? How am I going to deal with those things? Luckily, each local office has an attorney who's either stationed in the office or shares offices, so they're between maybe one or two counties.
This particular case was domestic violence between mom and dad, and there's also some allegations of some possible drug use. The child was in the presence of the parents when the domestic violence occurred, and was able to, it's a 3-year-old child, and he was able to recount exactly what he observed, and it's pretty serious, pretty severe.
I mean, we're deciding daily as a child's safety issues, if children should be reunited, should parental rights be terminated, should parents have increased visitation, what services should work for a family. You need to bring this information to the court. I may agree or disagree with you, but I need to get that information from you. I need to get it from the CASA, I need to get it from the parents. But with regard to collecting provider reports, getting provider information to the judge, it's just key.
Talk to everyone involved so you feel confident about what you're going into. The attorneys are very easily accessible, so you can go speak with them and kind of staff your case briefly, even if it's just 5 or 10 minutes a couple days before or the morning before your court hearings, so that they can give you some advice about what you're getting into. Talk with your supervisor, staff your cases with your coworkers. And again, let the family know. When I walk into court today, the department's recommendations are going to be this, and this is why. And I hope that you can respect and understand that, even if it's different. And a lot of times it's not. A lot of times you're partnering with families, and what you're requesting of the courts or informing the courts is not a surprise at all to the families, and they're very much on board with what you're doing.
I want that information. And I want you to know your case. I promise when you come in the court, I'm going to know the case. I'm going to know what's in the file, what's been filed before, and I'm going to have read all the reports. The judge should not know the case better than the caseworker. And if you don't know the case, then ask for continuance and say, Judge, I am not ready to go. You can't come and just sit there and take up a spot in the courtroom and not know your case and not have the plan. Okay, here are all the barriers. Okay, how are you addressing those barriers towards reunification? I don't know, nobody got back to me, I didn't, it's not acceptable. I won't do a hearing unless I've read all the paperwork, because I want to have some information when I go into the hearing, and then you can ask questions and get additional information.
And little things like dates of birth and who the parents' names are sometimes things that we get tripped up on because, oh, I thought we were going to be here to talk about the facts, And then there are these, sometimes minor details, seemingly insignificant details, but we have to establish that the people that we're talking about are actually children. That has to do with your date of birth. Those are the things that are important.
The judge sent the child home with mom over our objections, over guardian ad litem objection, over home-based objection. Yes, it's kind of unusual to happen, but that's what happened. And she just kind of let mom know that I'll be going out there very often, very frequently, and I will, probably once a week, and the guardian ad litem will as well, and it was agreed that we'll be putting another home-based provider in.
Sometimes that happens. You win some and you lose some, and there's nothing more true than that in child welfare. There are some things that we feel, this is 100% blue, and you walk out of court and someone else said, no, that's yellow, and you think to yourself, what did I do wrong? And that's not the question you should be asking yourself. The question you should be asking yourself is this in the child's best interest? And if you can ultimately answer that question with, yes, I just disagree with it, or I disagree with the outcome for these reasons, it's okay. We're here for the child's best interest. And if the judge sees it differently, the judge sees it differently.